This is the most significant reform that we will have had since the Housing Act 1988, as far as the private sector is concerned. But all these other provisions that are coming in at the same time, if you're a private landlord, I think you will probably be thinking these are quite onerous. And if you're not, neutrally at least, it could be said that they are extensive. And we'll go through them as to how they're going to work together. So where are we with the bill? The bill has reached the House of Lords report stage. There was a scheduled sitting on Tuesday just gone, 1st of July. There are 2 more scheduled sittings in the report stage. They only got through the tabled amendments to do with the tenancy reform, not all of them, but some of them on Tuesday. We don't know quite yet what was adopted or not. Some of the tabled amendments in respect of the parts of the bill that I'm going to talk about are going to be probably discussed in the next 2 sittings. What happens thereafter, we don't know, because we don't know when we're going to get to the final reading of the bill. Summer recess, Parliament recess, starts on the 22nd of July. And that's important because it was hoped that royal assent would be given prior to the summer recess. That seems unlikely now. So when Parliament returns in September, that's more likely to happen then, with a commencement date later on this year. We don't know what that's going to be. So if the bill is passed, it will become obviously the Renters' Rights Act 2025. The version that I'm working from, the bill that I'm working from, is the one that was brought up from the House of Lords committee stage in May 25. So the version and what I'm going to discuss is from May. It may well change before it becomes law back end of this year. So just bear that in mind. There are some new concepts introduced by this bill, entirely new. And this is in a nutshell, in a summary at the beginning, what we're going to be looking at. So the Landlord Redress scheme, not a new concept. It already exists in some form within the social housing sector, but there's going to be a specific one for the private rented sector. We've got the private rented sector database. That is a new concept. That's going to come in as well. Rent repayment orders are spicing up. They're getting quite extensive. Decent home standard, an existing concept, applies in the social housing sector already. It's going to be introduced into the private rented sector. Superior landlords are going to get it in the neck quite a lot. There's quite a few amendments to do with superior landlords. Civil financial penalties are really spreading their wings. They're going to apply to quite a lot of new offences, so we'll look at that. And then we're going to be working on 3 different amounts for reasons which I'll explain. And then to give effect to all of this and to make sure that it has some impact, the government's proposing a revised and strengthened enforcement focus on local authorities to make sure that these provisions are enforced against private landlords. So we'll look at what that means as well. But before we start looking at each and every one of them, the definition of residential landlord is important because all of them will be referring to this residential landlord. So let's look at what that means. It doesn't mean a live-in landlord. It means the landlord under a relevant tenancy of a dwelling in England that's not social housing. Dwelling has the usual definition, which is not going to surprise you. And then relevant tenancy means an assured tenancy or a Rent Act tenancy. And we know all tenancies are going to become assured tenancies. So it's going to apply pretty much across the board. There is a definition section in the bill, which you can look at in due course. But moving on to the Landlord Redress scheme itself, I think it's going to be similar to the Housing Ombudsman scheme. The Act, when it comes into force, is not going to introduce the actual scheme. It will simply introduce the concept of the scheme. Regulations are then going to be coming in after the Act that will tell us how it's going to work, when it's going to start, who's going to be the relevant person, etc. And the purpose of this, it can be pretty self-explanatory, but it is for complaints to be made about landlords who are members of the scheme. And the complaints can be made by either a prospective tenant, current tenant, or former tenant. The scheme is meant to allow for those complaints to be investigated by an independent individual, and it is meant to provide an independent review and determination of that complaint. What the subject matter of the complaint can be, who the independent individual is going to be, all of that detail is going to come in regulations. So we don't know yet, certainly not from reading this bill. To give it weight, what the bill is proposing is that regulations can also make it so that any determination by that independent individual can be enforced as a court order. So it's giving it some oomph behind it to carry it through. Alongside setting up the scheme, there are then going to be a number of requirements imposed on private landlords, these residential landlords, to comply with certain requirements under this section. So they might be, for example, those who are members of the scheme, they might have to provide information even before a property is marketed for letting. They might be prohibited from marketing unless the landlord becomes a member of the scheme. They might require the member to remain a member even after they cease being a residential landlord. They could make provision for information to be provided when requested and certain specified information. Again, all of this is going to come through in regulations. But if the landlords fail to comply with those requirements, there are going to be civil penalties imposed. If it's a mere contravention of the duty imposed on them to provide some information or register on the scheme, there's going to be this first tier of penalty. So we're going up to £7,000. If there's a contravention and then something else happens which makes it a specified offence, which is specified within the bill and will be in the Act, that offence is then punishable by a penalty up to £40,000. And the offences work on the basis of escalation of initial conduct. So if you look at paragraph 18 of your handouts, of my handout, an offence under this is if you've had a penalty imposed for a contravention. So let's say you're meant to register as a landlord under the scheme, you don't. You get a penalty of up to £7,000 imposed on you. So you pay that. You sit around for 28 days, you do nothing about registering yourself. Day 29, you've committed an offence. And then you're liable again up to £40,000. If the same has happened at the beginning, you've had the penalty imposed, but you do rectify your conduct for not registering, but then you commit a different breach within the next 5 years, you've committed an offence again. So they can go again against you up to £40,000. And it's so on. So you'll see that there are some other offences that follow through. So that's the landlord redress scheme in a nutshell, because it doesn't give us a great deal other than it's going to be introduced, and then these penalties and these consequences are going to come in. So I'll move on to the next concept, the new concept that's being introduced, which is the private rented sector database. The database itself, the concept of it, will become live when the Act comes into force. But the actual operation of the database is not until regulations come in and introduce it. The purpose of it is set out within the Act, or within the bill. It's to be operated by the Secretary of State or a person who the Secretary of State has arranged to be the operator. It's meant to contain entries in respect of persons who are or intend to be registered landlords, and in respect of dwellings which are or are intended to be let under residential tenancies. So you've got to keep 2 active entries, one for you as the landlord, one for the property that you're letting out. And then we've got entries relating to banning orders and banning order offences. But the first 2 of those are going to catch pretty much every private landlord in the country. So we've got the setting up of the database itself. As I say, that's going to come through regulations. The bill already introduces certain sanctions and restrictions for not complying with these requirements. So there are these restrictions on marketing, advertising, or even letting the property. If you don't comply with keeping an active database entry, you could have restrictions imposed on you on the marketing of dwellings. You could be prevented from letting it out, etc. So those duties and requirements, again, are going to give rise to penalties, similar to the ones that I described in relation to the Landlord Redress scheme. So up to £7,000 for a mere contravention. And if you commit an offence, up to £40,000. And the offences take the same format of escalation of conduct. So I won't go into those. But a really interesting one on top of this, the penalties, is if you are in breach of a requirement to have an active entry, whether it's a landlord entry or a dwelling entry, and you apply for possession, the court cannot make a possession order. That's going to be an amendment to Section 7 of the Housing Act 1988, unless you've relied on ground 7A, the absolute ground, or ground 14, which is the antisocial behaviour ground. Everything else, you can't get an order if you haven't got an active entry. So that's quite a significant sanction that's being imposed, along with obviously then the penalties as well. Rent repayment orders. I don't know if you're familiar with them, but obviously the Housing and Planning Act 2016 introduced these. They seem to be more common in the South, I think, my understanding is. But they are available. They have been available for some time. There is a specified list of offences in Section 40 of the 2016 Act, and that list is getting revised. It's extending. So the available offences for which you can get an RRO are now going to include all the offences under what will be the Renters' Rights Act to do with tenancy reform. The offences I've spoken about, Landlord Redress Scheme, database, they're going on the list as well. So you can get an RRO in relation to those. At the moment, you have to make an application for an RRO within 12 months of the offence being committed. That's going up to 2 years, so giving longer to tenants and any other applicant to make that application. And the amount that's going to be awarded is going up from 12 months rent to 2 years rent. So quite significant increases there. Superior landlords. You might have heard of the Supreme Court decision of Rakusin and Jepson from 23. The Supreme Court decided in that case that the current legislation as it stands does not allow for an RRO to be made against a superior landlord. The bill is tackling that head on. Superior landlords are now expressly included and will be under the Renters' Rights Act as somebody against whom an RRO can be made. And then we've also got companies and directors or relevant officers of companies being liable at the same time. So Section 51A of the 2016 Act is coming in. It's being introduced by the bill, and it's similar to what already operates under the Housing Act 2004, which is Section 251 about corporate bodies being liable. Their officers can be liable at the same time. They can be deemed to have committed the offence. So a similar provision is being brought in relation to this. So that's an overview of the RROs. Decent home standard. Now, this is quite interesting. There's a lot behind this that's going to come in that it's dealt with very briefly in the bill because all it's doing is making amendments to Part 1 of the Housing Act 2004. Part 1 of the Housing Act 2004 already has conditions imposed. It's all to do with conditions of dwellings and making sure that properties are up to scratch. And this is where the Decent Home Standard sort of comes from. You might have heard about Category 1, Category 2 hazards. There are prescribed hazards. There are 29 of them. That's set out within Part 1 of the Housing Act 2004. They're amending, or they're introducing a new section within that part, Section 2A, which is going to talk about additional standards to be set for qualifying residential premises. And those additional standards could, again, by way of regulations to come, could address things to do with the state of the repair of the premises, things to be provided for use by or for the safety, security or comfort of persons occupying the premises, and the means of keeping the premises at a suitable temperature. And there are going to be Type 1 and Type 2 requirements to do with this subject matter that's on the slide. So we've already got Category 1 and Category 2 hazards, Type 1 and Type 2 requirements. Quite what the difference is going to be between the two, I don't know. Because, for example, excess cold is a prescribed hazard under the Housing Health and Safety Rating System. So what's the means of keeping the premises at a suitable temperature going to add to that? It'll be interesting to see. But we don't know because the regulations haven't been done yet. Once the regulations come in, it'll all become clear, no doubt, we hope. There is already a duty under Part 1 of the Housing Act 2004 on local authorities to take enforcement action when there is a Category 1 hazard. There is going to be a similar duty or the same duty in relation to Type 1 requirements. So those changes have already been made or are proposed within the bill. Category 2 hazards, there is a power to take enforcement action on local authorities, and I think the same is going to be replicated in respect of Type 2 requirements. A new thing that's come in is that alongside serving an improvement notice for Category 1 hazards and Category 2 hazards, and now what will be Type 1 and Type 2 requirements, local authorities can serve a penalty of up to £7,000 at the same time as the improvement notice is served, if it would have been reasonably practicable for the responsible person to secure the removal of the hazard or the meeting of the requirement. So it's a relatively low threshold set, reasonably practicable to remove it. I can't see that being too much of a problem in being met most of the time. So that's an interesting development as far as that is concerned. But in the background of all of this, there's some other things that are happening. So even after the Renters' Rights Act comes into force, the current Decent Home Standard, which is the one published back in the early 2000s, is going to be the relevant one, but the Conservative government in 22-23 reviewed it and consulted on it. Labour don't want to rely on that consultation, they want to do their own. So that's yet to come. The Decent Home Standard is yet to come. And it's all interlinked with these Type 1 and Type 2 requirements. So until we have this consultation and review, I suspect we're not going to get the regulations. On the back of all of that, the Housing Health and Safety Rating System, HHSRS, the operating guidance that's been published since 2006, that tells enforcement officers how to assess Category 1 and Category 2 hazards. Whether that will include Type 1 and Type 2 requirements, I don't know, or whether there's going to be a separate guide to those requirements. But that is part of the Decent Home Standard. That has been reviewed, that has been revised. There is a document in existence, it hasn't been published. It's not going to be published until they revise the Decent Home Standard, that's what the government has said, but it can't also be introduced until they pass regulations to introduce it. So there's quite a lot to do in order to get this up and running. So the commencement date that you might get back end of this year isn't going to mean a great deal for this part of the Act, the bill. There's going to have to be a lot more work done and a lot more for us to digest and get through. Okay, so moving on to superior landlords. This is following on from the lack of express mention of those with superior interest in the legislation. They've tried to then look at where else can we bring it in and expressly set it out. Section 72 of the Housing Act 2004 creates an offence for failing to license a licensable HMO. Section 95 is an offence for failing to license a property that's within a selective licence area. And those two provisions are similar in terms of who they catch. They catch persons in control of or managing either the HMO or the property within the selective licensing area. And what the proposals are under the bill is to amend these two sections to include those with superior interests, so they're widening the net of responsible persons there. And there will also be a possibility of serving an improvement notice on superior landlords in certain situations, and this is paragraph 2 of Schedule 1 to the Housing Act that it's going to seek to amend. So I'll just leave that there, flag it up, because if you don't deal with these, it might not be of that much interest to you. And then moving on to these civil financial penalties, you might be aware of the Housing Act 2004 and the penalties that can apply in respect of a number of specified offences within that Act. So failure to licence, HMOs, a failure to comply with improvement notice, and so on. Those penalties are set at up to £30,000 within the Housing Act 2004. There is nothing within this bill which seeks to amend that amount and bring it in line with the 40 that's proposed here. Whether that will be done by way of regulations afterwards, we don't know. So we're going to have that system operating under the Housing Act 2004, £30,000, and the same for, I think it's the electrical safety standards. They have penalties up to £30,000. This bill, and then the eventual Act, introduces this up to £7,000 and then up to £40,000 for these new offences that are created, and extends the application of these penalties, or the one up to £40,000, for Protection from Eviction Act offences. So they will also now fall within the remit, but under this Renters' Rights Act, not the Housing Act 2004. So yeah, you've got the new offences that we've talked about, which are created by amendments to the Housing Act, a lot of them to do with tenancy reform, and then the Landlord Redress scheme, as I've mentioned, and the database. And then to give effect to all of this, to make sure that this is all being enforced, local authority enforcement is getting a real new focus under this bill. There's going to be a duty on local authorities to enforce this landlord legislation. And landlord legislation is all of the things that I've talked about. That's all falls within that, and the Protection from Eviction Act as well. It doesn't include within the definition of landlord legislation the Housing Act 2004 provisions of the electrical safety regulations. But everything that's mentioned in the bill, that's part of the landlord legislation. So there'll be duties on local authorities to do that. Local authorities can go outside their geographical area and take enforcement action in other areas. And I think the purpose behind that is to allow those who are better set up with either more housing officers and environmental health officers who can deal with it, and those with better in-house, I say better, more resourced in-house legal teams who can maybe take action in other areas. There may well be a duty to report to the Secretary of State on what the local authority has been doing in terms of enforcement, if that's requested. So a justification as to whether the local authority has been sitting on their bottoms doing nothing, or have they actually been doing something. The Secretary of State may designate a lead enforcement authority in a particular area, may give directions to that lead enforcement authority as to how to exercise all these functions. And to top it all off, there might be some money changing hands. The central government is proposing to give money to local government in order to enforce these provisions. Now, these are all just suggestions by way of what might happen. Whether it will happen, we'll have to wait and see. But there's quite a significant reboot on the focus of how this is all going to work. And I think having brought the provisions in, they want to see them enforced. So again, we'll wait to see what actually happens. There are a number of investigatory powers introduced in the bill, obviously, to help local authorities do this enforcement. So they're similar to what's already out there in the Housing Act 2004. Not quite the same, but very similar in nature and what it's seeking to achieve. So just finally, things to look out for. I started off with this by saying the bill version is what I've talked to you about. There are tabled amendments that concern some of the things that I've talked about. One of the interesting ones is what the database entries should be. So we know that it's entries to do with the dwelling, entries to do with the ID of the landlord. There's a proposal that what should go on there is any RROs that have been made against the landlord. They should be included. I get the logic in that. There's also another tabled amendment that any Section 8 notice served by the landlord should make its way onto the database, including the grounds that were used. That seems a little extensive. There's also a suggestion that the rent at the commencement of the tenancy should be recorded with any variations throughout the tenancy and the last rent payable at the end of the tenancy. We'll see whether that will pass. And there are a few attempts by a couple of Conservative peers to try and knock down the penalties from 40 to 20,000 and from 7 to 4,000, and some other amendments to standard of proof to do with some of the offences, etc. So it'll be interesting to see what happens, but it's a warning from me that once the Act comes into force, don't come back to this handout because it will be out of date. Look at the Act, to state the blindingly obvious, but just to make it clear. I've covered the royal assent date. I don't know when that will be, but likely September. Commencement date, back end of this year, most likely. And then a whole ream of regulations to come that will keep us busy for the next, I think, 2-3 years just to get our heads around it.